Welcome to WG University, Weber Gallagher's series of educational programs. This is our employment group webinar series. I am Tracy Walsh, and I am presenting today with Christina Abreu from our Philadelphia office. Today we are presenting a current topic in employment legal issues. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website, www.wglaw.com, and you will find copies of the presentation and others under the WG University page. Also, feel free to contact the firm with any questions at wglaw.com. Today's presentation is Workplace Investigations, Tips for Conducting Internal Workplace Investigations of Harassment and Discrimination Claims.
Hello, today we're going to be looking at effective anti-harassment policies and procedures. These anti-harassment policies and procedures should be in your employee handbook and explained to your employees on an annual basis. We're also going to look at the importance of conducting prompt and thorough investigations. Basically, we're going to be looking at why you should take your employees' complaints seriously and how to do so. And finally, we're going to look at the procedures for conducting workplace investigations. These are going to be the steps that an investigator should take to conduct a proper investigation. First, we're going to talk about the anti-discrimination laws. As everyone knows, there are federal, state, and local laws that prohibit harassment in the workplace on the basis of protected categories. The federal laws include Title VII of the Civil Rights Act of 1964, the Pregnancy Discrimination Act, the Age Discrimination in Employment Act, and the Americans with Disabilities Act. These laws are enforced by the Equal Employment Opportunity Commission, also known as the EEOC. And there's also in New Jersey, the New Jersey Law Against Discrimination and the Pennsylvania Human Relations Act. Just some statistics so we know what we're working with. According to the EEOC, in 2017 in New Jersey, there were a total of approximately 1,600 charges filed. Of those charges filed, 533 had to do with race discrimination, and approximately 440 had to do with sex discrimination. In Pennsylvania, there was approximately 4,500 charges filed in the EEOC, and of those charges filed, 1,100 had to do with race, and about 1,200 had to do with sex discrimination. And so that's why these are important topics to discuss today. The categories that are protected by these laws include sex, race, age, religion, and disability, among other things. And the EEOC defines harassment as unwelcome conduct that is based on race, color, religion, sex, which includes pregnancy, national origin, age, disability, or genetic information. Harassment becomes unlawful where 1, it's enduring the offensive conduct becomes a condition of continued employment, or 2, the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. And this is where it becomes a hostile work environment. Why are these policies important? Well, they may resolve the complaint once it's made by the employee. It helps avoid legal action by the employee. It could prevent future occurrences of this prohibited discrimination. It also may result in the discovery of other employees with same or similar claims. According to the EEOC, the employer is automatically liable for harassment by a supervisor that results in a negative employment action, such as a termination, failure to promote or hire, and loss of wages. If there is a hostile work environment due to a supervisor, the employer can only avoid liability if it can prove that It reasonably tried to prevent and promptly correct the harassing behavior. And two, the employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer. Therefore, anti-harassment policies are very important to try and prevent harassment of its employees. It also serves as an affirmative defense if legal action is filed by an employee. There's also a negligent retention claim, which is a type of employment-related claim in which a plaintiff asserts that an employer failed to discharge an employee who management knew or should have known had a propensity towards violence, sexual harassment, or dishonesty. And so effective anti-harassment policies and procedures, and here are some tips. Employers should have written anti-harassment policies which are distributed to all new hires and employees. It's best practice to have these policies reviewed annually to make sure they're updated by the law, and also reviewed annually with employees in order to answer any questions on an annual basis. You all should have the employee handbook signed and acknowledged by each employee and redistributed.
So in addition to what Christina described as should be included in your anti-harassment policies, these policies should also define harassment. Again, utilizing the EEOC definition is certainly appropriate. What is harassment? What is a hostile work environment? And what are the protected categories? The policy should also describe whether it covers verbal and physical conduct and should cover both. It should indicate the company's policy that it has a zero tolerance policy for harassment. And very importantly, the policy should also set forth a complaint procedure that directs employees to whom he or she should report harassment, whether it is initially a supervisor and then a human resource official, or a department manager, or a president or committee of the company. But it should also include more than one individual, because it could happen that the alleged harasser is actually the individual supervisor, and therefore another individual to report harassment to should be included in the complaint procedure. Also, with regard to confidentiality, the policy should indicate that as best as possible, an investigation will be kept confidential. However, it should not guarantee confidentiality, since the investigation will likely result in witnesses being interviewed. An effective anti-harassment policy should also inform employees that upon receipt of a complaint of investigation, that the company will conduct a prompt and thorough investigation. And lastly, the anti-harassment policy and complaint procedure should also include a separate anti-retaliation policy, which informs employees that if a good faith complaint of harassment or discrimination is made, that the individual who made the complaint will not be retaliated against, nor will any witnesses who cooperate and participate in the investigation be retaliated against. And as Christina indicated earlier, one of the reasons of many to have an anti-harassment policy and complaint procedure involves the affirmative defense that was initially enunciated in two Supreme Court decisions in 1998 known as Farragher and Ellerth. Those cases involved a sexual harassment complaints. However, the decisions apply to other types of harassment as well on the basis of race, religion, disability, etc. If the alleged harassment is committed by a supervisor and that harassment culminates in a tangible job action, then the employer is vicariously liable for the actions of the supervisor. In other words, the employer is strictly liable for the actions of the supervisor. However, if the acts of the supervisor do not culminate in a tangible employment action, or if the alleged harassment was committed by a coworker or a non-supervisor, then the employer has a two-pronged affirmative defense to the vicarious liability. And the employer would then need to show that it exercised reasonable care to prevent and promptly correct any harassing behavior, and also that the employee unreasonably failed to take advantage of preventive procedures put in place by the employer. So then how does an employer show that it exercised reasonable care in order to be in a position to assert this affirmative defense? Well, there are a number of ways. Most importantly, that the company does have an anti-harassment policy with a complaint procedure. And we cannot emphasize enough that it should be in writing. The company can also show that it provides training to its employees, that it trains all its employees on the policy and the procedure, and that the company also takes complaints seriously, that it has a history of taking complaints seriously that are made by employees. Also, the company can show that it conducts prompt and thorough investigations. The investigation should be commenced immediately, and it should be thorough. And lastly, the company can show that it exercised reasonable care because it takes appropriate remedial action in response to a complaint of harassment after the investigation has concluded.
So now let's talk about conducting the investigation. Once you receive a complaint, then the time starts ticking. First, you have to decide who conducts the investigation itself. Should it be internal or an outside investigator? Your policies may already state who conducts the investigation in your company. However, there may be other issues that come into with the complaint that make you decide to use an external versus an internal. However, we're going to be focusing this presentation on an internal investigation. The factors to consider are who is the complainant, who is the alleged harasser, the qualifications and experience of the investigator. For example, if the alleged harasser is a senior executive, CEO, or owner of the company, you may find it's best to use an outside investigator versus an internal investigator. Also, if the internal investigator has a conflict or is part of the complaint, then it's best to use an external investigator. For the in-house investigator, typically it should be a human resources professional, someone who's objective, experienced, a good communicator, and patient. They should also have the time to devote to the investigation. These investigations, depending on the type of complaint and how many witnesses, could take some time, and it definitely needs to be devoted to and taken seriously. They cannot be the object of the complaint or a witness. That would impact their objectivity, which is very important to these investigations. The investigator should also be familiar with the company's policies and procedures and follow them accordingly. And you also want to make sure that there are no internal conflicts when it comes to identifying your in-house investigator. We also wanted to bring to your attention that when you identify who the in-house investigator is, that the investigator becomes a fact witness at the conclusion of the investigation. In this way, they may be called to testify if there's a legal action when a complaint is filed by either of the employees. And when they are called to testify, there's going to be scrutiny on whether the investigator's investigation was prompt, thorough, and adequate. Those things will be questioned if they're called to testify in a litigation. So when you're preparing for an investigation, you need to start with an investigation plan. First, you need to review and be very familiar with the company's policies and the complaint procedure. You also need to review all relevant documents, and that would include if it was a written complaint, and the personnel files of the complainant and the alleged harasser. This will help you determine the scope of the investigation. It'll also help you identify the initial witnesses and prepare you for the entire scope of the investigation. also in a time-wise to let you know exactly how many people you have to meet with and how much documents you need to review. In addition, you need to review other physical evidence that becomes available before the interviews. And this would be if the complainant, for example, said something about, their inappropriate emails. You could ask, IT to pull those emails beforehand, for an example. And then you have to make a decision of whether to record your interviews with the witnesses or not to record. Before you go to record any type of statements you have with the witnesses, you should be familiar with your state law. For example, it differs between state. In Pennsylvania, you need two-way consent to record. In New Jersey, you need one-way consent. Just one individual of a conversation has to give consent to record. However, it's atypical to record in these scenarios because it may hamper the witnesses from providing a statement or providing you information. And any recordings that you make in this process do become discoverable in a litigation. And so it also will bring scrutiny to those witness interactions, which might not otherwise be the case. So you always want to start with interviewing the complainant. When you first meet with the complainant, you have to explain the process of the investigation and the company's policies. Assure the complainant that the company takes the complaint seriously and will conduct a prompt and thorough investigation. This way the complainant understands exactly what is going to take place and the steps that the investigation is going to begin, and also that it's going to end at some point and how it's going to end with the completion of a report. When you speak with the complainant, you want to get the version of the incidents. It's the who, what, where, when of the alleged harassment that occurred. You want to start with open-ended questions, and then as the complainant provides you more information, try to narrow down the details as much as possible. You also want to make sure that you get any witnesses to the incident, and so that's why it's important to know if it happened out in the open, if it happened in the break room, and those types of things, because you would also get witnesses, but also if there's any video recordings of that area as well, it'll help you narrow that down. And then you also want to ask the complainant whether there were same or similar incidents occurred involving the complainant themselves or any other employees. Typically harassment happens with not necessarily just one person, but other people complain of the same type of thing, but no one has brought it up to the employer. So it's very important to ask if they had heard of any other types of complaints from similar situated employees. Finally, you want to make sure you ask the complainant for physical evidence. This would include any documents, notes, emails back and forth, text messages, Facebook posts or messages on any other type of social media, audio recordings, photographs, or video. And once the complainant is able to provide you with this evidence, you make sure you document it in your notes, and then it would be used as part of your report once you're ready to start writing the report. When you're interviewing the complainant, you also want to ask questions about their relationship with the harasser. What's their work and reporting relationship? Is it an employee with a supervisor? Or is it a social relationship? Were they friends or even dating in the past? Also, if they had a past and present relationship. You want to also avoid guaranteeing 100% confidentiality. One, you have to provide information to the witnesses about why they're being interviewed. Secondary, you will be completing a report that will go to human resources and for higher ranking individuals in the company to review and make a determination on. And finally, if you have a litigation, then the report and all of the information will become part of the litigation and is discoverable. Lastly, you don't want to promise the outcome of the investigation, because when you first meet with somebody, you're just gathering facts and information. So it's very premature to begin with.
After the complainant is initially interviewed, then the next interview that is suggested to take place is the alleged harasser. Under the same circumstances as the complainant was advised, the alleged harasser should be advised that a complaint has been made and that an investigation of the facts is being conducted, that nothing has been predetermined and no decisions have been made. The alleged harasser should also be advised that confidentiality will be maintained as much as possible but again, it cannot be guaranteed as others may need to be interviewed, but best efforts will be made to keep the investigation as confidential as possible. You would now have all of the allegations from the initial interview with the complainant. So as you meet with the alleged harasser should be asked about each allegation that has been made by the complainant, and you can therefore, as you go along with your investigation, determine what has been corroborated or not corroborated, at least as between the complainant and the alleged harasser. As done with the complainant, the alleged harasser should also be asked for any physical evidence. And importantly, by the conclusion of that interview of the alleged harasser should be advised and reminded of the company's anti-retaliation policy, and that no retaliation should be taken against the complainant, him or herself, as well as any witnesses who may be involved in the investigation as it progresses. In addition, depending upon the relationship or the reporting relationship, if any, and the work environment between the complainant and the harasser, as well as the nature and extent and depth of the allegations, it may be necessary to suspend the alleged harasser, or to at least separate the alleged harasser and the complainant during the pendency of the investigation. As long as both are working in the same environment, then guidelines should be given to the alleged harasser as to how to conduct him or herself in the workplace during the pendency of the investigation. Next, there will be interviews of any witnesses who were identified. All witnesses should be interviewed that were identified by the complainant and the alleged harasser. Also, as you are going through the investigation and based on the interviews that you've conducted to date, there may be a determination of other possible witnesses in the same work environment, and those witnesses should be interviewed as well. When meeting with witnesses, the purpose of the investigation should be stated, such as, I am investigating a confidential human resources complaint relating to your department. After all these individuals have been interviewed, then there may be a need for follow-up interviews. There may be a need to go back to the complainant and or the alleged harasser for additional questioning as a result of those witness interviews. Witness statements from all the individuals who were interviewed should be pursued. Those statements can be prepared by the investigator based on each interview, and request that each witness review it and sign off as to whether it's true and correct. Finally, at the conclusion of the interview process, any additional investigation that may need to be conducted as a result of what was learned, such as any additional physical evidence and pertinent materials, such as personnel file materials, should be reviewed by the investigator.
So now we're going to talk about the investigation of the report. First, we're going to talk about the nature of the complaints and just describe what the allegations were made by the complainants. Then you go into the scope of the investigation and identify all of the individuals that were interviewed, including the complainant and the alleged harasser. I also like to add the date of which we met with the witnesses, just so it's there in the report. Then you want to have your relevant physical evidence, and this would be any of the emails, documents, notes, or Facebook posts that you've printed to add to your report. Then we have the factual findings. In this case, you would take each of the allegations of the complainant and make a factual finding as to whether they were corroborated or not by witnesses or physical evidence. And remember, the standard that we're referring to in this investigation report will be whether the allegations were sustained by the individuals or not sustained. And we have the definitions up there for whether it was sustained or not for you to review. At the conclusion of the report, you're going to determine whether the factual allegations were corroborated or not, and determine if there were any violations of the policy. Remember that the report is kept confidential internally. However, it may be discoverable if legal action is filed. And finally, we want to remember that your investigation report has to be prompt, impartial, and thorough, because that is what is going to be scrutinized if there is litigation. In-house non-legal investigators typically review factual findings with higher-ranking executives or the committee, and sometimes with in-house or outside legal counsel. And at that level is where it's determined whether there was a violation of the policy and whether any type of remedial action will be made, whether it's from just removing individuals or separating them into different areas of the office space or up to suspension or termination.
In closing the investigation, the investigator or the appropriate decision makers who were involved with regard to the remedial action should advise the complainant and the alleged harasser in separate meetings of the outcome of the investigation, advise both the complainant and the alleged harasser of any remedial action that will be taken. So if any action is going to be taken with regard to the alleged harasser, such as additional training or counseling or disciplinary action, or even up to termination, those types of actions should be documented and placed in the alleged harasser's employment file, and the complainant should be made aware as to whether certain remedial action is being taken that he or she needs to be cognizant of in the event that the alleged harasser violates any of the procedures that were put in place. This report can and should be kept in a separate confidential file, and any physical evidence should be preserved by the investigator. And briefly, with regard to the other types of investigators that can take place, we wanted to make you aware that if an outside investigator is retained, this would be an independent, non-employee investigator of the company. It should be kept in mind that any communications between that investigator and the employer, as well as any and all witnesses interviewed, and including the report itself, will all likely be discoverable if legal action is filed. Obviously, one thing to keep in mind with an outside investigator is that it can be more costly to the company than if an in-house investigator who was an employee was used for the investigation. And also with an outside investigator, an employer should be mindful and be careful about any legal conclusions that the outside investigator seeks to make. Finally, if the outside investigator or even the in-house investigator is legal counsel, it should be kept in mind that this individual, even though he or she is an attorney, still will be a fact witness if there is any legal action taken following the conclusion of the complaint, and any legal opinions that are rendered could be kept confidential as attorney-client privileged, although that cannot be guaranteed. So the legal opinions that an outside or in-house legal counsel provides should be recognized as possibly not being privileged if the matter should proceed to a legal action. Thank you for attending our webinar, Workplace Investigations, Tips for Conducting Internal Workplace Investigations of Harassment and Discrimination. Our next program will be on April 24th from our Philadelphia office, and will be about social media. You can learn more about this program and all other Weber Gallagher events by visiting the following site, www.wglaw.com/WG-University. Thank you.